Friends, now we look into the Justice Arun Mishra judgment on E.V. Chinnaiah case. We know that E.V. Chinnaiah case is having some importance in the field of reservations. So, now the 7 judges bench is also considering whether E.V. Chinnaiah case has to be revisited or not. The basis for that consideration is Justice Arun Mishra judgment. It is delivered August 2020. So, the issues covered in this matters are 16.1, 16.4, 338, Article 338, Article 341, Article 342A, etc. Now, the exposition of the law in Indira Sahani is not correctly followed in E.V. Chinnaiah case. That is the doubt. The exposition of the law in Indira Sahani judgment, 1992 judgment, has not been followed properly, correctly in E.V. Chinnaiah case. That is the doubt. Then come to the basic issue. So, subclassification. Whether subclassification within scheduled caste is permissible or not. That is the discussion. In Andhra Pradesh, 2001 Act has been enacted. That is called the Scheduled Caste Act 2000. That is rationalization of reservation. Rationalization of reservation. This is the Act. SCST, Rationalization of Reservation Act 2000. Basing on Justice Ramachandra Raju Commission, report, scheduled caste has been divided into 4 categories: A, B, C, D. Again, percentage of 15 also appropriated among these 4 groups. Now, it was challenged by, this act has been challenged by E.V. Chinnaiah before High Court of Andhra Pradesh. High Court of Andhra Pradesh upheld it, upheld the act after elaborative discussion. Then matter carried forward to Supreme Court. Supreme Court set aside the act. So, that judgment is E.V. Chinnaiah judgment. Now, what are the arguments of the petitioners who are supporting revisiting of Chinnaiah? So, they are finding faults with Chinnaiah. What are the faults? According to E.V. Chinnaiah judgment, giving preferential treatment or subclassification of scheduled caste is amounted to tinkering of Article 341. Because what Article 341 says, we must understand. What Article 341 says, it is regarding presidential order. It is regarding presidential order. Let us see what is Article 341. You see, it deals with the power of President to declare which are scheduled caste. So, the President may, with respect to any state or union territory. So, first one is the President may, with respect to any state or union territory. Suppose if it is a state, so after consultation with governor, so what it is saying, for the state, consultation with governor is necessary for the President. Thereof by public notification. So President will issue public notification. Saying what? Specify the castes. By notification which carries, what is the notification? It is specify the castes, races or tribes or parts of group within castes, race or tribes which shall for the purpose of this constitution be deemed to be scheduled caste in relation to that state. Now, so this is called presidential order or presidential notification. So, which caste, race, tribes or parts of or group within caste, race or tribes which shall for the purpose of this constitution be deemed to be scheduled caste. So, what is scheduled caste will be specified by the President. That is Article 341. Now come to Clause 2. Parliament may by law include in or exclude. So Parliament may by law include in or exclude from. Include in or exclude from the list of scheduled castes specified in a notification issued under Clause 1 any caste, race or tribe or part or group within any caste, race or tribe, but save as aforesaid a notification. Though you come here only, then we will see later part. Who can include or exclude? Not President. Declaration power has been given to President. The scheduled caste, the declaration of scheduled caste, the power given to President. But include and excluding power has been given to Parliament, not President. Include in or exclude from the list of scheduled castes specified in a notification issued under Clause 1. Once President issued a notification under Clause 1, again President cannot change that notification by issuing another presidential notification, subsequent notification. issued under the said clause shall not be varied by any subsequent notification. So President has no power. What is power? Who is having power? Only Parliament. So that is the different. This is Article 341. Now come to this judgment. What is here? So whether it is tinkering of the 341. In E.V. Chinnaiah case, Supreme Court held that, the bench held that giving subclassification is amount to tinkering of 341. Is it correct? That is the discussion now. So, according to the arguments of supporting revisiting of Chinnaiah or otherwise opposing Chinnaiah, they are saying that merely giving of preference does not tinker. Merely giving of preference does not tinker, rearrange, subclassify, distribute, disturb or interfere with the list in any manner. So, just because giving preference is not amount to tinkering, because it is not disturbing or it is not interfere with the list in any manner. So, because no inclusion, no exclusion of any caste in the list. So, the Punjab state government has done this type of preferential treatment. So, the Punjab Act has been enacted under Article 16.1 and 16.4, read with Articles 245 and 246. Now, see, what is 16.1, 16.4 and what do you call 245, 246. Yes, come on. Now see 16. Now it is having several classes. This is regarding equal opportunity in matters of public employment. Article 14 deals with the equality. Article 16 deals with the equal opportunity in matters of public employment. So here the 16.1 says there shall be equality of opportunity. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. So, there shall be equality of opportunity for all citizens in matters relating to employment or appointment any office under the state. That is one. So, employment or appointments, any office under the state, no discrimination. Equality should be prevailed. Next, clause 2. No citizen shall, on grounds only of religion, race, caste, sex, descent, place of residence, or any of them, be ineligible or discriminate against respect any employment office under the state. So, because of is having different religion, different race, different caste, different sex, descent, place of birth, residence, or any of them, be ineligible for or discriminated against any employment. Next. Nothing in this article shall prevent Parliament from making any law. So, this is general principle and generic principle. This clause is against discrimination. Now, this clause again is promoting discrimination. Of course, affirmative action, constructive discrimination shall prevent Parliament from making any law prescribing in regard to class or classes of employment or appointment office under the government, any local or other authority within a state or union territory, any requirement as to residence within that state or union territory prior to employment and appointment. This is called local and non-local. So, Parliament from making any law. So, Parliament has to make a law. For what? Prescribing. For prescription. In regarding to class or classes of employment or appointment to an office under the government of or any local or other authority within a state or union territory, any requirement as to residence within that state. So, by law, local or non-local, that means residence can be prescribed. So, to hold an employment, one must reside one place or one must having residence that can be fixed. That is another clause. Now come to clause 4. So, nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class of citizens which in the opinion of the state is not adequately represented in the service under the state. So, it is again a type of positive discrimination. What it is saying? Nothing in this article shall prevent the state. So, 16.1 or 16.2 or 3 or total entire 16 shall prevent, that means shall not prevent the state from making any provision. It is provision, called provision, not law. Of course, provision also comes from the law. For the reservation of appointments or posts in favor of any backward class of citizens. So, suppose in the opinion of the state that backward class is not adequately represented in the services under the state, is not adequately represented in the services under the state, then it is the opinion of the state, it can make such reservation. Next. Come to, this is the, what do you call, 16.4 is positive discrimination. Next. 4a. Nothing in this article shall prevent the state from making any provision for reservation in matters of promotion. This is called promotion. 4 deals with the posts, employment and appointment. 4a deals with the, what do you call, promotions with consequential seniority to any class or class in the service. And suppose promotion has been challenged, reservation in promotion, whether is a Nagaraju judgment, a landmark judgment. So, even in promotions also, with consequential seniority to any class or class of post in the service under the state in favor of schedule, which in the opinion of the state are not adequately represented in the services. So, this is in the opinion of the state is pari materia. This opinion of pari materia 4 and 4a. This is regarding appointment, this is regarding promotion. So this is the Constitution broadened the reservation provision for job promotions encompassing individuals belonging to scheduled castes and tribes. So encompassing individuals. So this is Article 16.1 and 16.4. The reservation in appointments or posts under Article 16 of the Constitution is restricted to initial appointment. Further, it cannot extend to a reservation in matters of promotion. The interest of these SCs and STs will be harmed by this Supreme Court decision. It is vital to continue the current dispensation of offering reservation promotion for the scheduled caste and scheduled tribes. Since they, so requisite level. So this is called Y4A. Y4A has come into picture. Y4 has come into picture because the state is unable to give reservation to certain people because of 1, 2, 3. So 4 has been enacted. Now the state is unable to give reservations in promotions. Why? Because of the Indrasani judgment. What is Indrasani judgment? Indrasani held that was reservations only for initial appointment. 16.4, Article 16.4, only initial appointment. It cannot extend that to promotions. So now this judgment is affecting the interest of SC/STs because of some SC/STs are not being promoted to some of the posts to requisite level. So the government has chosen to maintain the prevailing policy of reservation in the promotion of the. So that's why 4A has been added. Now, so this is 2002 judgment. Come to 4B. Unfilled vacancies of a year which are reserved for being filled up in that year in accordance with any provision for reservation made under class 4 or 4. Separate from considering any unfilled vacancies as a separate class of vacancies to be filled up in any succeeding year or years, and such class of vacancies shall not be considered together with the vacancies of the year in which they are being filled up for determining ceiling 50% reservation on total number of vacancies that year. This is 4B. It is also a little bit complicated, but that is not relevant for this purpose. That's why we are holding here. Now come to the judgment again. Now what is the difficulty in E.V. Chinnaiah? They are saying that Indrasani held against the subclassification, but in reality, Indrasani says, among the backward, there may be some more backward. And when state choose to make such classification, it would be permissible in law. So, classification is permissible within the one state. Backward classes can be classified into more backward and less backward. So, they can be classified in that way. Okay, now 16.4 covers all backward classes, including scheduled caste and scheduled tribes. The expression used in 16.4, any backward class of citizens, any backward includes SC and STs also, and not adequately represented covers all social and educational backward classes, who on account of their backwardness are adequately represented in the state service. So the scope of Article 16.4 is wider than 15.4. So the expression backward classes used in articles covers in its ambit is scheduled caste and scheduled tribes. And the preferential treatment is a facet of Article 14. Now come to other aspects. Thomas case. What is Thomas case? What is Jarnail Singh case? So here, what is K.C. Vasantakumar case? We will see. In Vasantakumar versus State of Karnataka, which was approved in Indrasahani, it was held that subclassification between backward and more backward classes is necessary to help more backward classes. So, Vasantakumar and in Balaji and others versus Mysore, 1963 itself, it was held that subclassification, Balaji case, subclassification between backward and more backward class is necessary to help more backward class, 1963 itself. Now come to State of Kerala versus Thomas. In Thomas case, it is held that there could be no objection to further classification within a class. So, there could no objection, further classification within classification, within a class. Because men are born different, and some sort of differential treatment is required to achieve proportional equality. So here what is proportional? What is the goal? Substantive equality or proportional equality? Substantive is different, of course, in the views of, in the opinion of Chief Justice, it is called substantive, but here the proportional equality is important. So this is part 1. We next come to part 2 later.